Court rise.
Oh, wait.
Court rise. Appealing the matter of Azarmi and Bassiri.
Yes, Miss Owens. Well, it's very nice to be back in court, and it's very nice that everyone has felt able to come to court today.
My lady, thank you.
Can I just tell you that we've all had an opportunity of reading the papers, so we've read the two judgments, we've dipped into the relevant local relevant authorities, and of course read your scouting arguments.
My lady, my lords, I abhor on behalf of the appellant, Mr Azarmi-Movafagh, along with my learned junior, Mr Tate, and Miss Phipps appears on behalf of the respondent, Miss Bassiri-Dezfouli.
Yes.
My lady, I'm no doubt going to slip into husband and wife.
Certainly.
No disrespect, but they're both appellants because, of course, we've got an appeal and a cross appeal. I'm grateful that you've got the appeal bundle and the authorities bundle, and the authorities bundle covers both of our cases. Miss Phipps and I were able to agree that last week. I don't know if you, my lady or my lords, are using electronic bundles.
Not this morning, I don't think.
No. Super. Then you don't need to know that the pages are a couple out.
No.
My lady, my lords, Miss Phipps and I have spoken about a timetable. I don't know whether you are concerned about that.
Well, I think that three of us felt that given the amount of reading we'd done and it being a relatively narrow point, we thought we'd probably get through it quite quickly. But
well, let's
perhaps
hope
you don't agree.
No. We have simply said we're obviously very much in your hands as to what you're interested in, but that we have a day and that we would take up to 2 hours each, but maybe not 2 hours,
yes,
with half an hour each for a reply if necessary.
Oh, gracious. Right. Well,
yes. My lady, it may well be that that is an overestimate. So you will know from your reading that these are cross-second appeals from the decision of Mrs Justice Judd, and that the first instance decision was that of His Honour Judge Robinson at the Central Family Court, and that was a 3-day final hearing. My lady, my lords, do you want page references as I sort of skip through the background? Would you like them just for your notes?
Are you talking about the background to the...
I'm just going to skip through how we got to where we are today.
Right, well, if you just want to give us the page references as we go through
so
for our note.
The judgment of His Honour Judge Robinson is at page 102 to 108 of the bundle, and the order is at 109, page 109. And the wife appealed that judgment, the judgment that was a lump sum of £625,000, comprising a housing fund of £400,000, £25,000 for costs of purchase and car and a little bit to set up a business, and then the £200,000 that is the biggest issue today. And directions were made by Mr Justice on the 2nd of October, and one of those directions was for my client to file a reply. That reply was filed, but mistakenly, without seeing it, Mr Justice Cohen gave permission to appeal. And that's at page 115 of the main bundle. And I would ask you, if you wouldn't mind, to turn to that. So at permission to appeal is given at paragraph 1. And at paragraph 6, Mr Justice Cohen says, the analysis put forward by the wife of the cost regime does not seem to me to be helpful. The judge has a discretion as to how he deals with liabilities, but a party who incurs excessive costs cannot expect them to be met by the other spouse. Mm-hmm. Now, whilst I recognise that that is not necessarily pointed at Mr Azarmi, we say certainly that set the scene for what happened thereafter. And those instructing me wrote in when we received the permission to appeal because they'd filed the reply. And at page 116, you will see that Mr Justice Cohen considered the matter afresh.
Yep.
And he regrets that the papers were not put in front of him. But at paragraph 3, he says, my decision remains as before for the reasons already given. I would add only that no consideration seems to have been given to some of the respondent's costs being a charge on his new property. And so that is, we say, my decision remains as before, which is that the party who incurs excessive costs can't expect them to be met by the other spouse.
Well, that's not a decision.
Well, no, but as I said,
these are reasons for giving permission.
My
no
lady,
more than that.
Yes, we say though that by the time Mrs Justice Judd came to look at it, it had set the scene, because then he says, he mentions the charge, and of course you will know from the papers you've read, my lady, neither party wanted a charge. So the first,
say neither party wanted a charge. Was that said in writing by each of them in their position statements?
No, because, well, I didn't attend the appeal last year before Mrs Justice Judd. I had done the reply, but my client was in person because he had run out of money. And but as I understand it, certainly told the court in a later document that neither party had asked for a charge. It may be that she can assist you with that.
Ms Phipps, sorry to go to you straight away, but could you just clarify that for us, please?
My lady, my recollection is that it wasn't actually discussed during the course of the appeal hearing itself. The learned judge decided to impose a charge in relation to the costs, and then subsequent to that, I wrote a document on my client's instructions objecting to that. But during the course of the hearing itself, it wasn't mooted as a solution.
Thank you. Yes, Ms Holmes.
My lady, so the appeal came before Mrs Justice Judd remotely. We were in the teeth of the first lockdown at the time. And the judgment, I think, is dated July, and it was handed down formally on the 10th of September. And her judgment and annex is at page 75 of the bundle. And the order follows on at page 84 to 85. It's a fairly simple order, understandably adding the charge. My lady, given what you've said, I won't go into the detailed background of the case in terms of the ages of the parties, but just really, unless you tell me otherwise, that the wife had owned properties of about 2.3 million after CGT. That CGT figure was about £700,000, thereabouts. And it was conceded that all the assets emanated from her and that this was a needs case. My client had debts of £257,000. It won't be the last time you'll hear that figure today. And the wife had debts of £300,000. Some of those debts were an issue, but that's what His Honour Judge Robinson found. That's what he used. And of that £257,000, about £122,000 was owed to my client's sister. And that was for legal fees and for living costs. But there was no breakdown as to how much. But His Honour Judge Robinson was concerned about this £257,000, including fees for the Children Act case, where it was agreed there should be no order of costs, and fees for the criminal proceedings. And so he had a specific for a breakdown, and those instructing me did the calculations, and you will see them in the judgment. So the debts were very much in issue from the off, really, at the final hearing. And if I could ask you, my lady, my lords, to turn to page 106 of His Honour Judge Robinson's judgment. And it's paragraph 21. In paragraph 20, he sets out the debts. And he says this is an area which Mr. Wilkinson raises with some force. Why, he says, should the husband be allowed to set his costs of the proceedings, of the Children Act proceedings, and above all the criminal proceedings against the joint assets? On the other hand, Mr. Owen says, if I do not provide for his debts, how can his needs be met? I record that the criminal costs are 13,150 and the children proceedings 48,864. His costs of these proceedings are more than hers. Mr. Owen says this is because, at least in part, of the wife's litigation conduct, in particular in respect of the abortive intervention. So it was very much in His Honour Judge Robinson's mind that not all of the £257,000 was the financial remedies costs, but he knew the precise figure for the children costs and the criminal costs, and you will know what the order that he made. He specified in his judgment that the monies owed to my client's sister, whose evidence he accepted entirely.
She'd put a charge on her house.
Sorry?
She'd put a charge on her
Yes,
home.
some of it she'd borrowed on very high rate credit cards, and the rest of it she'd put as a mortgage on her property. And she gave evidence from Australia by video link, and he accepted her evidence. And he said in his paragraph 32, which is the second to last paragraph at page 108, I do think it would be wrong to say that the cost of the criminal proceedings and perhaps some of the cost of the children proceedings should not be his responsibility from his own resources. I'll award him a sum of £200,000 towards the costs, which will go a long way to dealing with them, will certainly allow him to pay off his litigation loan, and will allow him to go a long way to pay off his sister. He then has to decide on the balance of what he does with his money between his housing and payment of the soft debt. So we say this is completely consistent with other decisions that have been put before you, where judges have considered they do have, they can deal with costs as a liability, as a hard debt, but that they can make a different order for different reasons. And one of them being, for example, that they are from different proceedings. For that appeal before Mrs Justice Judd, my client who represented himself, his position was that His Honour Judge Robinson was not wrong. Leave the order as it is. But the wife's position remained as in the worst instance, which is that Mr Azarmi should get nothing.
Well, I mean, this was the absolute classic case of both parties being wholly unrealistic about the approach to litigation, which is why we are. The wife was saying absolutely nothing after an 11-year marriage where there's a child, and the husband was wanting £1 million.
Well, my lady...
And there we are, £500,000 out of 2.3 million wasted on costs.
We say...
Before we get here today for the second appeal.
We say, my lady, that his position was not as extreme. Firstly, because his position of the £995,000 was put forward in his Section 25 statement when the assets were higher. So it wasn't, by the time we got to the final hearing, it looks like a disproportionate amount. But in the Section 25 statement, it said 35%.
Yeah, but that was his position at the hearing when they knew when the position had crystallised.
Yes, my lady, yes. You will know that at the appeal, Mrs Justice Judd, she found that the judge's assessment of the housing need was unassailable and the £25,000 changing, but that he was wrong to allow my client to recover the lion's share of his costs, where he'd been found to be violent by the deputy.
No. That was not. Can we just look at the judgment? Because I certainly did not read her ladyship's judgment as saying because there'd been a finding of violence, therefore that was the order she was going to be made. Certainly something she mentioned, and I know that you take exception to it. I understand why. But I think to categorise the reasoning of the judgment to be wholly based on that
Well, she mentions it
somewhat extreme.
She does mention it may be useful to deal with this because it's, of course, one of our grounds. She says in her judgment at paragraph 29, which is, I beg your pardon, let me start with, I've taken you to the paragraph where Mr Wilkinson, on behalf of the wife, raised the fact of the other proceedings. But
sorry, we're in Mrs Justice Judd's judgment.
Yes.
Right, so what paragraph?
Let me find that. Paragraph 29 on page 81, please, my lady.
Right.
So it's the last full line. The judge, and I note that the husband, I've concluded there's force in the point, she starts, about the issues as to the husband's debt. There are no orders to cost in the Children Act proceedings. There are no proper grounds on which a cost order could have been made at the end of the financial remedy proceedings. Whilst the judge acknowledged it would be wrong to say that the cost of the criminal and the children should not be his responsibility from his own resources, the order he made, in fact, allowed the husband to recover very much the lion's share of his costs from all the proceedings. And I note the husband chose to pay his legal costs when he could have obtained public funding. The judge did not really explain why this was, or to set the payment of such sum in the context of the wife having to pay her own very substantial cost bills, and particularly where the deputy district judge had found the husband had been violent to her by assaulting her.
I'm aware of that, and I've read
occasion.
it, but your submission a moment ago was that the reason the judge allowed the appeal and made the order she did was because she wrongly had based it on the fact of the finding of violence in the Children Act proceedings, and I don't read the totality of the judgment as...
Can I ask you, my lady, to look at paragraph 4 of the Annex at page 83, please?
Yes, now this is the... Why was this redacted, please?
It was redacted because it dealt with costs.
Sorry, I don't follow.
My version isn't redacted.
No, our bundle, I had to ask for an unredacted version. I just wondered why anyone...
I can only apologise, my lady. I certainly have an unredacted. When I printed it out, mine was unredacted.
Ms Phipps said that you've got an unredacted copy.
Mine was redacted, and then I received the unredacted version as a consequence, no doubt, of your ladyship's intervention yesterday.
Fine, thank you. All right. So I'm looking at the unredacted version. I think my lords are also.
So at paragraph 4 of page 83, so this is the annex when Mrs Justice Judd was asked for further reasons. Yes. As to the reasons for the trigger, the sum required for housing is based upon the husband's position who is not able to pool his resources. Also, I considered that the trial judge was wrong to allow the husband to recover the lion's share of his costs, particularly in circumstances where in the Children Act proceedings the district judge had found that he had assaulted the wife on 2 occasions.
That goes to quantum, not as to whether it should be a charge, though.
Well, my lady, we would say it was so much in her mind, she mentions it twice.
Okay.
If you look at paragraph 32 of His Honour Judge Robinson's judgment, he says that the sum he is awarding of £200,000 towards his costs, towards the husband's costs. So the £200,000 was the judge's quantification of the amount that he was ordering the wife to pay towards the husband's costs.
My lord, yes.
If you look at paragraph 5 of his judgment, that sets out that his costs of the husband's cost of the financial remedy proceedings is 177, Children Act proceedings 49, and criminal costs 13. So the judge is right that he ordered the wife to pay the lion's share of the husband's costs.
Yes.
That's a correct characterisation of what happened.
Yes, my lord. But what he did was, he knocked off £57,000, taking into account that the 48 or 49 plus the 13 was about 62. But
Anyway, you say that you're pinning your appeal on those 2 comments of Mrs Justice Judd.
it's just one of our grounds, my lady. Certainly not. It's one of 7 grounds. Perhaps I could move on to the first ground, my lady, unless
You're...
in terms of perhaps before I move on to mine, in terms of my learned friend's grounds of appeal, which are at page 49 of the bundle, we say that, well, number 1 isn't a ground really. It's the wife agreeing with Mrs Justice Judd in relation to not fully recovering the costs. But in relation to ground 2, we agree that Mrs Justice Judd shouldn't have charged the payment. That's the one thing we agree about. So in 2A, we argue the opposite of this. We're concerned that it'll be triggered sooner and that it puts Mr Azarmi at risk of not having his needs met. But also, in the meanwhile, the level of acrimony will continue because there's a vested interest in the wife knowing what he's doing, whether he's in a relationship. And we say that the order, if it's triggered, will almost certainly take my client below the level of his needs. In relation to 2B, well, this is part of our argument, which is regarding needs and the judge's discretion to determine them, and I'll deal with that as part of ground 1. 2C and D, we wholly agree with. We agree it contravenes the clean break principle and that it wasn't sought. So in terms of the first ground, our first ground, which is I know the court will be well aware of this and I can take this fairly swiftly, why we say His Honour Judge Robinson was not wrong. And these are covered in our skeleton by the well-known principles of the first instance judge's discretion, which you will know, generous ambit. We've referred your ladyship and your lordships in our skeleton argument to the well-known principles set out by Mr Justice Moore in WD and HD, but referring to Baroness Hale in Re B, only wrong if it's outside the band of reasonable decisions. We say it simply wasn't. Highly unlikely that 2 different judges will exercise their discretion in identical ways. Was the exercise of discretion unreasonable? If it cannot be said that it was, the appeal will be dismissed, and we say that's what Mrs Justice Judd should have done. And that she therefore was wrong to add the charge. We also cite FF, Mr Justice Mostyn in 2017.
So are you taking just take us to which paragraphs you're referring to in your Skelton argument?
It is
I'm talking about,
it should be under ground one.
well, your ground one begins at paragraph 27. Talk about discretion at 29.
So it is FF and KF. Sorry. Page 27. Yes, the top
I have
of
it.
the top of. I'm grateful to my lady friend. The top of page 27, and that is where Mr. Justice Mostyn says that there is, so far as the needs principle is concerned, there's an almost unbounded discretion, and he talks about the fact that there are different definitions of needs, but needs are relative. So he talks about the Mills-McCartney case and how Mrs Justice was awarded 62 million to meet her needs, and in AAZ and BBZ, the court assessed the wife's needs at £224 million. It's a term of art, and that's why it's an unbounded discretion, because every case is different, and that's why we say that His Honour Judge Robinson can't have been wrong. And then we cite the well-known passage from Piglowska, which is, of course, that the appellate court shouldn't, that's in paragraph 27, the appellate court should resist the temptation to subvert the principle that they shouldn't substitute their own discretion for that of the judge by a narrow textual analysis, which enables them to claim that he misdirected himself. We say that this judge did take into account everything he needed to take into account. Certainly, if you look at the case law, which I'll turn to next in terms of ground 1B, are costs a different category of needs? And effectively, what's being said on behalf of the wife is that because the husband's debt's mainly related to costs, they fall into a different category. And my learned friend sets out the cost rules in financial remedy cases, the one we know, which is that the usual rule is that there's no order as to costs unless there's litigation conduct. And we say it's simply not accepted that it's an established restriction because of Family Procedure Rule 28.35, the no order of costs, and that his discretion didn't extend to taking into account his costs as a hard debt as he could any other. Indeed, we submit, my lady, my lords, that it's entirely conventional for the court to do just this if they're hard debts, and that superficially there are cases that I will take you to, if I may, that look like they say otherwise, but we say those cases actually accord with precisely what His Honour Judge Robinson did, and they show the discretion of the trial judge to take costs into account as a hard debt, as a need.
Sorry, you asked the question, are costs a different category of need? What's your submission as to the answer to that question?
We say that costs can quite properly be taken into account in the section 25 exercise as a hard debt.
Look, I'm not speaking for myself, I'm not sure that's an answer to the question as you posed it. Costs a particular type of need?
Well, I suppose it was a different category of need to a credit card debt or any other type of hard debt. or soft debt for that matter? Do they stand as a separate category? And we say on behalf of Mr Azarmi that they don't, but that the court may treat them differently in the same way that the court may treat a soft debt differently. I shall start, if I may, with the case of S&B, which is a decision of Mr Justice Wilson, as he then was. It was a 2004 case reported in 2005, pre the cost rule change. And this is at tab 3 of the authorities bundle, starting at page 55. This was a very short marriage, it's about 2.5 years. And the wife had no capital. There was a matrimonial home in Chelsea, unencumbered. And District Judge Moylan, as he then was, ordered the wife to receive a minimum of £465,000, but if the sale proceeded at the agreed figure, she would have got £475,000, 66%. There was a child aged 3 and the wife worked full-time. The husband was in a maisonette with equity of about £56,000, 66 by appeal. And the husband had been made redundant in the September 2002, and he was still unemployed at the date of the appeal in September 2004. But he had created all of the wealth. And at paragraph 12, at page 59, Mr Justice Wilson set out what the costs were. So the acrimony between the parties following that is reflected by liabilities for legal costs, which are out of proportion. The judge has greatly simplified my task in this respect by setting out the following clear figures. The wife's costs of the ancillary relief, £152,000, of which she had paid £63,000 and of which £89,000 remained outstanding. Cost of the Children Act proceedings, £47,000, she'd paid £15,000, so £32,000 outstanding. And there at paragraph C, the wife's outstanding costs were £121,000. And then the husband's costs were £129,000, he'd paid £74,000, £55,000 outstanding, and his Children Act costs were fully paid up. Now, in this case, in part, the level of costs was high because the wife had instigated an investigation into loan repayments from the husband to his parents that the judge ultimately concluded were genuine. And it was a 4-day trial with a reserved judgment just for a few days. Both parties had leading counsel. And District Judge Moylan made an order for the wife to receive £475,000 and no order as to costs. The judge said the £350,000, which was too low for the housing, and she's got to pay her outstanding costs. So he gave her £475 in all, so about £386 for her housing fund. And
which paragraph are we at?
Well, Mr Justice Wilson says at paragraph 6, page 63, please, para 26. He says, I hold that, provided that when he came to determine any issue as to cost, he bore well in mind what he had done. The judge was fully justified in adding into the lump sum payable by the husband the wife's outstanding costs, referable to the financial proceedings. Indeed, it was the only realistic sum open to him. So that included the Ancillary Relief and the Children Act proceedings. And Jonathan Cohen, Queen's Counsel for the husband, argued that there should, I think at first instance, there should be a charge. And at page 65, your ladyship and your lordships, at paragraph 34b, it was suggested that District Judge Moylan had rejected a charge because the level of acrimony mitigated against a charge. But importantly, in paragraph 35, and this is what distinguishes this case, which my learned friend relies on, from the one the one before the court today, at the bottom of paragraph 35, Mr. Justice Wilson says, and it's the last 5 lines, the line starting, I propose to follow the reasoning of my colleagues, save in the event that the other factors as yet unconsidered, for example, in relation to costs, compel a different result. I uphold the conclusion that the wife is likely in the years ahead to earn the value, free of a husband's charge, of a modest 3-bedroom flat in West London. So we say that's a big difference in this case. And if we turn to paragraph 38 at page 66, Mr. Justice Wilson said that the judge needed to approach the issue of costs with 2 facts firmly in mind. Within his lump sum order was provision for payment by the husband of £89,000 in respect of the wife's cost of the financial proceedings. Within an order for maintenance pending suit made in January 2003 had been provision for payment by the husband of £3,000 per month in respect of the wife's cost of the financial proceedings to be credited against any ultimate liability of the husband to pay or contribute to her cost. And under that order, the husband had paid £23,000 in respect of such costs. So in other words, the award of District Judge Moylan meant that the husband was paying £112,000 towards the wife's costs. And at paragraphs 39 and 40 is the part that my learned friend relies on, which is that the husband was paying a sum higher than would have been achieved on a standard assessment. But importantly, at paragraph 42, firstly, Mr. Justice Wilson says that the Calderbank offers, all of the wives were unrealistic, whereas 3 of the husbands were reasonable or close to being reasonable, and that the wife failed to negotiate in any meaningful way and made the cost of the hearing inevitable. So she's criticised because she ran the bad point on the loans and then for those other matters. And at paragraph 43, he says, I have no doubt that the bulk of the hearing was taken up with the issue of the parents' money, and on that issue the wife has lost. The preparation of the hearing has concentrated on that. And at paragraph 46, 13 lines down, Mr. Justice Wilson said that the parents' loan point, the inquiry, and thus the costs on both sides became completely out of proportion. He then goes on to say, at paragraph 47, there is no question of my making an award of cost to the husband which would entitle him to set any part of it off against the lump sum payable to the wife. Nevertheless, to say of a litigant, this is the bottom of paragraph 47, since she cannot pay him now, she should never pay him, is to stand justice on the head. So the difference in this case is that Mr. Justice Wilson was actually saying that, all else being equal, the wife should be paying some of the husband's costs because of litigation conduct regarding the parents' loan and the unrealistic Calderbanks. But importantly, in this case, because then what Mr. Justice Wilson does, and as I said, my learned friend relies on this, this is a case where the Mr. Justice Wilson said there should be a charge. But the important point is that there'd been a finding that she would be able to repay that charge. that's the paragraph 35. I uphold the conclusion she's likely in the years to earn the value, free of a husband's charge. So that's not replicated in the case before the court today. Within the first instance proceedings, the wife, at the direction of the court to provide property particulars, provided property particulars of around 240,000. Mr Justice Cohen, in his permission to appeal, ordered the parties to put property particulars forward again. I don't know what they were, but I know that it was suggested that properties could be purchased for under 300,000 by last year, because of course we're now nearly two years on from the assessment of property particulars, a suitable property at 400,000 ex costs. But we say Mrs Justice Judd doesn't go on to consider what my client would have left if the charge was triggered. She just says he'll have to get somewhere cheaper. So if there's a payment of 200,000 on a £400,000 property, subject obviously to house prices, you know, that's 200,000 to rehouse. And no one in this case has ever said £200,000 is enough for Mr Azarmi to rehouse. But the last paragraph of S&B is important because it sets out a principle. And my learned friend noted it. This, of course, is before the rule change on costs. So but it holds good because it looks to the future. So the last paragraph on page 69, starting the consignment to history of Calderbank correspondence in proceedings for ancillary relief, and thus the emergence of an ability to treat a party's outstanding costs as one of his liabilities definitively within the substantive judgment, i.e. without the need or indeed opportunity for such subsequent consideration as may demand that their earlier treatment be undermined by the Calderbank procedure, is hugely attractive, such as demonstrated by the present case, which the judge fell against what can best be described as a trap wire. And so that's what the amendment to the rules provided, the ability to treat the party's outstanding costs as a liability. And in S&B, the charge was ordered in a situation where, had the assets been greater, a cost order might have been made against the wife. And that isn't the situation in this case. Because, and of course, that was also...
Well, I'm sorry, just while you're there, it did occur to me that whether he would have succeeded or not is another question, but the husband might have had a respectable argument on costs, a conventional argument on costs, given what happened about the interveners. Now, I know cost orders were made, but that would have been part of litigation conduct, plus the refusal to negotiate.
My lady, that's
but as I understand it, no formal application was made for an order for costs as opposed to costs to be treated as needs. Am I right about that?
No, and interestingly, I found, when I was preparing for this appeal, I found my closing notes. And what I said in my submissions to His Honour Judge Robinson is, if you consider his liabilities, his costs as a hard debt and take it into account in your order, I will not apply for litigation conduct costs. And we say the abortive intervention was not the only litigation conduct, and I'll come back to that as one of my grounds, because it's a matter of record. It's all set out on the face of the court, of many of the court orders in this matter. So even though your ladyship has said that my client's position of 995, well, you've mentioned it, certainly apart from His Honour Judge Robinson's suggestion that the parties had taken extreme positions, bear in mind that he still awarded him 625 against 995, whereas the wife's position was 0. The wife's position was you get the benefit of the what was referred to as the get out of jail free. I put a figure of £676,000 on this dowry that I've never enforced during the marriage, and I'll let you off that. That was her position. And that was her position throughout the entirety, right until the end. But there was no criticism of my client's litigation conduct. He was the applicant, and he had to meet her ever-changing case. I mean, we had 3 interveners at one point, and all of those interveners had to, there were defences that had to be drafted. And the level of his costs weren't criticised. Rather, I think, as my learned friend nomically, His Honour Judge Robinson says, although his costs of the proceedings are greater than hers, there is some reason for that. And I'm not going to deal with it in a mathematical way, but that's because in his judgment, he knew he was going to award him $200,000, so he didn't have to deal with the litigation conduct point. And
were written position statements handed in, or was that merely an oral submissions that you made?
It was an oral submission.
I mean, I understand that this
Yes.
was a hearing in front of the district judge.
Yes.
But it's common ground that was the basis that you were putting your case. Treat
Well,
this as a hard debt, and if not, I'll
absolutely.
be making an application in relation to litigation.
Absolutely, and you can see Francis Wilkinson arguing against it, and it was the paragraph 21 where it says Miss Owen says I've got to do this, and Mr. Wilkinson says this. It was a very hard fought point.
Yes.
So that's how you know that this experienced, circuit judge who had sat for many years as a district judge at the principal registry doing just this sort of work day in, day out, had taken it into account. In relation to, if I can move on then, to another case, the same type of case, I can perhaps go a little bit quicker. WG and HG, this is the decision of Mr. Justice Francis, which was relied on heavily by my learned friend, both in this appeal and relied on by her in the previous appeal. And she quotes, the quotes which are that people cannot litigate on the basis they're bound to be reimbursed for their costs. No one enters litigation expecting a blank cheque. And then, of course, Mr. Justice Francis says, doing the best I can to recognise that her costs are excessive and that she's presented an unreasonable case, but so as not to totally undermine her Duxbury. I'm going to add to the lump sum an additional $400,000. The wife's total costs were $926,000, and that included Children Act costs, it included Family Law Act costs, and the wife's financial remedy costs were £625,000, plus interest on the litigation loan. And of course, my client's costs were higher because he'd already been going some 18 months or so because of the 6 months wasted for the intervention. He'd already been paying interest on the litigation loan. So, but in WG and HG, this was a 12-year marriage. All the assets were non-matrimonial. By the trial, the assets were 12.2 million. And the wife didn't accept that there was little or no marital request. And
she came very late to an acceptance it was a needs case.
She absolutely did, yes. Only acknowledged late in the day that it was a needs case. She also considered running an ad-back case based on the husband having spent money on a property that he'd bought. And she also failed to disclose the purchase of a property. And Mr. Justice Francis said this was a serious act of non-disclosure. And he said her open position was completely unrealistic and totally outside the bracket of the outcomes, over 64% of the total assets. And of course, the court awarded her 1.5 1.5 million for a housing fund, 2 million for a Duxbury, which would produce £90,000, total lump sum of 3.65, plus £400,000 for her cost, in circumstances where she was so heavily criticised. But reduced from the 926,000 that was being asked for because of her needs. But a completely different case. It's very easy, as we know, to take the sound bite that people can't litigate on the basis that they're going to be reimbursed, and the blank cheque sound bite. It's very easy to take that and use that, which is what happened, because I think Mrs Justice Judd even quotes it. But when you look at the detail in the case, this was a lady who she lost £500,000 from her Duxbury fund. So instead of getting £90,000 a year for life after a 12-year marriage, she was going to get £75,000 a year for life. And as Mr Justice Francis said, that's still a small fortune for most people. And also, of course, with a housing fund of 1.55 million, she could have just had a £1 million house. Well, that's not so terrible. And of course, she could simply just trade downwards later on. So none of the criticisms in WG would apply to Mr Azarmi, and there's no flexibility like that for him. This is it for him. He's now 59, rising 60. And so Dagger and Banger, this was actually quoted to His Honour Judge Robinson, but again, we've distinguished that in our skeleton argument. In Dagger and Banger, the husband was found not to need to buy a home. The parties had always rented. And importantly, there were no liquid matrimonial assets. They were all in India. And this was a husband with a total income of 130,000 net, said to be on a career trajectory. It couldn't be more different. So to say this sets out a principle, it is simply not correct, because ultimately Mr Justice Holman found that he didn't need to purchase, and therefore his cost debts wouldn't prejudice his housing need. So they didn't need to be provided for in the Section 25 exercise. Whereas Mr Azarmi was found by both judges to require a property of about £400,000. And if he's got to pay his costs from his lump sum of £425,000, he's not going to be able to purchase a property. And of course, that is my learned friend's point for this appeal. She's saying no charge and no costs. So he gets £425,000, and you will know, my lords, that with a litigation loan that's been increasing at 14%, his debts aren't £257,000 anymore. So finally, MB and EB, which is in your authorities bundle, right at the back at page 179. And again, I can take this relatively quickly. So this was a short marriage, 4-year marriage, ending in 2004, no children, with a 2011 separation agreement. Mr Justice Cohen said the case was an easy one to settle if the husband had made a constructive offer. And he criticised heavily the way that the husband had run his case. And it's set out at paragraph 15 at page 183. In stringent terms, he has sought to argue that this marriage lasted for 17 years, during which time the parties remained living together. That he made a full contribution as a homemaker, all of the assets came from the wife. A claim that I described in my earlier judgment as risible, that he had a sharing claim, that there was a marital request, that the agreement entered into was of no relevance and was entered into under undue influence or duress. Every one of those proposals was misplaced and wrong. So,
what some of these authorities appear to show is an analysis of, in some respects, the court's approach would have been in respect of costs if the court was considering costs.
yes, my lord, precisely.
Did His Honour Judge Robinson undertake any analysis of what order, if any, absent need, he might have made in respect of costs, or what issues he might have considered, or?
Well, certainly he can have been under no illusion.
The fact is, it isn't in his judgment.
It's not in his judgment, my lord,
I
no.
can't pretend that it is.
What he said, the most he says is that comment, there is some reason for it.
So he didn't really undertake an analysis, so that it's not altogether easy to understand why he thought it fair, looking at the picture overall, that husband should receive 625,000, or including 200,000 towards his costs. He doesn't sort of explain it, other than it's a need.
It's a need.
And that's the extent of it.
Yes, I think that is right. Of course, it's very easy. It's easier, perhaps easier for me to understand it because I was there and I know what went on. For example, there was extensive cross-examining of the wife in relation to her litigation misconduct because I was teeing up my claim for litigation misconduct. And I'm just...
Well, I suppose in a way you'd say that it actually didn't need any further explanation because the position was, he said he needed a house, 400,000 was the figure, he had no other visible means of support, he was on universal credit.
Yes.
And so if he didn't get something towards his costs, he simply wouldn't be able to buy a house.
Precisely. And of course, it enabled him, at the end of a 3-day trial giving judgment at 5 o'clock, to not make findings on litigation misconduct because he knew that my client needed those debts, or the bulk of them, certainly the hard debts, to be paid, especially given his finding of Miss Nibbs.
I mean, one of the things that we don't see in his judgment is he refers to the net assets, but what we don't see is how much the wife was going to be left with after she herself had paid her costs, part of the total assets.
It's not in the judgment, but
which is what one would hope to see.
But it is, you can calculate it, my lady.
Yes, I can.
Given the figures...
Thank you, Miss Owen. Yes, I can.
No, I don't mean... one could calculate it. I mean, I have the schedule, the asset schedules here, and the figures he used were precisely my closing figures. So certainly I can...
So what was the figure that the wife was going to be left with after she paid the 625 and paid her own costs?
Well, taking into account, I mean, His Honour Judge Robinson found it was the 1781
yes.
net, and in that he calculated every single debt that Ms Bassiri had said she owed every
right.
single person.
It was the 1.787 then the figure after she had paid her costs?
Every single penny that she'd borrowed from anybody, even though I was asserting that there was no...
forget all that.
Yes.
I'm just trying to...
Yes.
I'm trying to get clear in my head.
So she would be left with 1.156 million, or thereabouts.
Sorry, 1....
178, 625. 1.156 million.
Before she paid her costs?
No,
After she paid
after net.
Thank you.
Her costs, which were set out at just over 300,000.
Yeah, no, I knew that.
That also, my lady, includes entirely capital gains tax of £725,000, which of course wouldn't all immediately become payable.
No, but that's conventional.
No, I'm
Yes,
sorry, that is
yes.
absolutely conventional. You wouldn't,
Yes, no, I accept that, but the point is, it's
well, we can't suddenly say, oh, but it doesn't really count as 1.1 because of the CGT,
No.
because that would undermine the way we approach
No.
calculation.
But for example, sometimes, capital gains tax can be treated differently. We don't know, for example, what the Treasury is
Are
going
you
to...
sure your 1.1 is right?
Well,
Well, I thought the 1.79 included deducting 257,000 in respect of the husband's death.
Yes, it did.
Must have included his costs.
Uh,
So you don't then deduct 625 from 1.79.
no, you're absolutely right, my lord.
Exactly,
So
you deduct only 400.
you'd add another £57,000 in.
Well, no.
No, that's not right.
You really add, because it's not 57. He's deducted the husband's debts, or the debts have been deducted without regard to whether they're being paid. So actually, you should add back
Yes.
257 to the 1.8, then deduct 625 from that. Because the husband's debts are not being deducted from the wife's assets.
Then that means the wife is left with 1.413.
Now, do you accept that that's right? Because obviously that's a figure that's going to appear in our judgments.
Well, I'm looking at, let me
what the-
just check it against His Honour's. I'm looking at a schedule which gives the total assets at
Well,
1.78
let's just go to the paragraph in his judgment as first.
781 million. That's
Paragraph 20.
It is, that's right. So we look at paragraph 20 of the judge's judgment.
yes. So the figure at in the last line, 1781389, which is effectively agreed, is exactly the figure that I have on my schedule.
Yep. But
And that's
then
after
That is
both sides' cost.
after
debts, including costs.
257,237 for my client and 300,433
And
for
I
the wife.
assume the 257 includes the litigation loan to the sister, etc.
Yes,
Because that's set out earlier in the judgment.
that's everything.
Right.
Yes.
So, as my lord says, if we're wanting to see how much the wife was to be left following the making of this order at that date, you add back onto the 1.781, 257,237, and then you
1781.
subtract 625. That must be right.
389 plus 257,237 minus 625,000 is 1.413626.
Right. Now that is the figure that I am going to say to you, my lords agree, we are going to work on the basis that at the date this order was made, that was the amount that the wife would have been left, subject to any objections that we'll hear from.
Maths works, as far as I can see, my lady.
Well, we should surely be able to agree about arithmetic. It seems no one can agree about anything in this case, but if we can just do the sums, it's a start.
My lady, in conclusion, in relation to this ground, which is the main ground, I would say, we simply say that costs can quite properly be taken into account in the Section 25 exercise without undermining the no order for costs rule. And that this applies with more force in needs cases where if you ignore those costs, it undermines the provision by the court of a party's needs, which of course it's enjoined by statute to look at. But what we can see from the sample of cases we've looked at is that costs as a hard debt might be treated differently where the party in question has failed on issues or exaggerated their claim or engaged in litigation misconduct, or even just like, I think it was the judgment of Mr Justice Cohen, where the costs were just very high for no good reason, excessive costs. And we say that's all part of the court's discretion, this very wide discretion under Section 25. And I just turn briefly, because it's my learned friend's point in relation to indemnity costs. She says, effectively, what he got was an indemnity costs order, because he got every penny. She sets out the different cases that say, usually you only get perhaps 70%. And what we say in relation to this is that it doesn't really matter if the court consider it as a need. And it's no different, for example, to when the court makes a legal services payment order. Or in Schedule 1 cases where a party will have their costs paid. And of course, even in Section 8 Children Act cases, there's common law. There's no fetter on the law that gives the court discretion to make those orders. And what they are is effectively payments in account of indemnity costs. Now, I accept that there's the undertaking to repay, certainly in relation to Section 22 ZA, but my learned friend in her skeleton cites Mr Justice Mostyn in GW and RW. And within that judgment, he cites Lady Justice Butler-Sloss in Goykovic. And she was discussing the old costs regime when she said, under the old, this was under the old rules and against a background of usually the wife's claim being limited to her reasonable requirements. And it's quoted in my learned friend's skeleton. But, in this case, the wife was obliged to make the application for ancillary relief and was obliged to go to court and pursue her application to its conclusion over 9 days in order to obtain a lump sum of $400,000 in excess of the last offer of the husband. We say, in this situation where my client, for a start, the wife was saying it was a short marriage. That was problematic. He had no choice to litigate because she was offering him nothing. And effectively, he was in the position that, I say the old wives, that the wives pre-White were in, as to having to justify his reasonable requirements, or we called them needs. Because she was saying, you get nothing. Because an 11-year marriage with a child, where Deputy District Judge Orkover found that he had played a significant caring role, she said, all the assets are mine and you've contributed nothing. It's a matter of record that this is a wife who, in her Section 25 statement, called him a career layabout, who viewed her as a lottery win, who said the very last words in her Section 25 statement are, what the husband is doing should be viewed as an asset raid. And what she's saying is, but what I will give you is the release of an asset that I say is worth £676,000, and but that if I do enforce it, and you ever go to Iran, and my client has siblings and elderly parents there, you'll go to prison and never get out. And so we say, if my client had applied for a legal services payment order and got it, that first appeal would have been unlikely to happen, we say, because the money would have been spent, it would be gone. And my client would still have had his housing needs met. The housing needs being agreed by both of the judges who've looked at it. And what he would have had is effectively an indemnity costs order if he had a legal services payment order. But because he was ineligible for a legal services payment order because he qualified for a litigation loan, he didn't have the benefit of that. So he failed the test in 22 ZA 4, which says, can you secure a loan? So instead of the fait accompli of the LASPO, he had a debt, and there was only one party who could pay it. My learned friend also says that, and this is at paragraph 21 and 22 of her skeleton argument, having quoted the GW and RW, the rationale for the no order principle applies to cases where the assets and matrimonial have been built up by the parties' joint endeavours. In such cases, both parties have a sharing entitlement, and therefore it's fair for both parties' legal costs to be deducted from the available pool of assets. It's accepted that the rules have changed, the law has moved on. However, the rationale for the view expressed by Mostyn J that there's a distinction between cases where the assets are matrimonial and those where they are non-matrimonial holds good. We simply don't accept that because, of course, my client is perfectly entitled to mount a needs case, which is what he did. And in any event, His Honour Judge Robinson specifically dealt with contributions in his judgment this is page 108, paragraph 33. He dealt with it earlier where he set out what my client had done. Although I found that the wife's position has been unrealistic, I do think she has a legitimate point in respect of the overall contributions, particularly in view of the fact that all of the assets came from her. I've based my decision very much on need. I do not consider this a case of unequal division, but on the other hand, I do not think this is a case where he should be expected to rent. I recognise that the sum I award, complicated as it is by the treatment, is a low proportion. So even including the £625,000, it's a low proportion. And so my learned friend says that the wife's had no opportunity to challenge the principle of the quantum of costs. Well, that may be true in terms of they've not been assessed, but the wife was successful via her counsel in reducing the debts from 200,000 to 257,000. And it is clear that that was taken into account by His Honour Judge Robinson. So we put the case that I do say on my client's behalf that Mrs Justice Judd mentions twice about the violence, which wouldn't, we say, constitute conduct pursuant to Wachtel. But in any event, he knocked off the 57,000, just a few thousand away from the figures that were assessed as.
Well, I think what you say about that is, one, the district judge knocked it off. So, in fact,
Doesn't matter.
That doesn't matter. But in any event, You told me, I think, at the beginning of your submissions, or told us at the beginning of your submissions, that the parties had agreed that the Children Act proceedings would be no order for costs. So no sort of VT application had been made by the wife that there should be an order for costs in the Children Act proceedings as a consequence of the findings made at the finding of fact hearing.
That's correct, my lady. But also, some of my client's debt to his sister was for living expenses, in the context of the wife having retained all of the income from the properties and her bar income, and my client being in a rented one-bedroom flat on benefits. So we say it wasn't unreasonable for him to have built up debts, and we say, we'll come back to it over and over again, what would be the position if the genders were reversed? And that's something that His Honour Judge Robinson refers to. And even in relation to Mrs Nibbs, His Honour Judge Robinson said, I don't know why she was called. Her evidence wasn't challenged. And yet, prior to the final hearing, the wife had said, I don't agree to her giving video evidence. She was supposed to be coming over for the hearing. So we had to make an application. The first thing we had to do before we started the trial was say, can she give evidence by video link? And she was then allowed, and then she was barely cross-examined. And as I said, that's set out in his judgment. So we say that's more litigation conduct. And
so now you've dealt with ground 1.
I've got, yes.
Dealt with ground 5 and 6. What else do you want to say about the...
May I just, in relation to ground 5, may I just finish a very small, a point in relation to that, is that, and your ladyship may not agree with me, but I do say Mrs Justice Judd took it into account, and this was in the teeth of the fact that at the first appointment, Miss Bassiri, via her then counsel, it's a different gentleman, both parties agreed that neither would pursue the issue. That is on the issue of conduct against the other in financial remedy proceedings. That was on the face of the order, paragraph 3 of the matter of record. But post-FDR, so we had the abortive intervention, and then we went back and had an FDR in front of His Honour Judge Meston QC. And it was clear from the FDR that the wife was still running a conduct case. So within that order, the post-FDR directions, it was ordered that if the wife continues to seek to run a conduct case, she shall file and serve a concise statement by the 7th of May 2019, addressing what conduct exactly she's seeking to rely on, the basis for her conduct allegations, what effect this should have on the current financial remedy application, and then the applicant had permission to reply.
Could you just tell me the date of that order, please?
Yes, the date of that order. It was the order of His Honour Judge Meston, and it was the 9th of April 2019.
Thank you.
And it's paragraph 4 of that order. I don't know whether your lordships would want a small clip of just the orders in the first instance, because that can very easily be delivered to you electronically. Now, no conduct statement was served or filed by that date, the date being 7th of May, but then her Section 25 statement, which was dated in July, was full of conduct. It had a whole section that was marked 10th of July, a whole section that was marked Section 25G, 25.2G conduct. And so my client was forced to make an application 1 week before the trial, on the 29th of July for the wife to redact her Section 25 statement. He'd had no, for a start, she didn't include in it why this made a difference.
Where are these points reflected in the judgment?
They aren't, Your Lordship.
So, how
But they are a matter of record in the court orders. But my point is it really just goes to the fact that Miss Bassiri had her chance to run her conduct point, and she didn't, and yet still Mrs Justice Judd took it into account. I'll take it no further than that. I take your point, Your Lordship. It's not in there, but we would say it doesn't have to be in there if what you can see from the court orders and from the documents of fact, there's no dispute that this happened.
Well, it's a more simple submission, isn't it, with respect? You say, there it is twice.
Yes.
In circumstances where there was no findings of conduct, it wasn't raised at trial, and in any event that it had been agreed between the parties that the Children Act proceedings would be no order for conduct. So,
My lady, yes. So I've dealt with ground 5. Ground 4A I can deal with fairly swiftly, which is that it was already a low proportion of the total assets that was recognised by His Honour Judge Robinson, and by virtue of the charge, that goes down even further. And of course, the wife, I've already addressed you on the fact that the wife's position for this appeal is no charge, no costs. And that's the same point. I don't see that my learned friend can gainsay that if that is the order this court makes, he can't house, because they've never put properties forward that are of that level. Ground 4B, which is that we've lost the opportunity for an order for costs in the husband's favour due to the wife's litigation conduct. I've already set out what we say the litigation conduct was, and I don't ask the court to take into account anything that's not on the face of a court order. Simply because the wife, who of course paid the intervener's costs that was agreed, but those weren't the total costs that my client had to spend. And a cost order was made against her by Deputy District Judge Cross on the 20th of December 2018 because of the aborted FDR, and those £3,000 never been paid. Interest is running, and the matters that I have taken you to in my skeleton argument, where I've set out what I've said in my closing submission, what I cross-examined on. But we've lost that opportunity. That is a problem. Grounds 2 and 3, which is the effects of the charge, I think we're agreed in relation that there shouldn't be a charge.
So is that the position? You're both agreed there should not be a charge. So effectively, you're both agreeing that this appeal should be allowed, and the argument is whether it's back to the original appeal or whether we should substitute a no charge, no order.
Yes. Well, I'll let my learned friend address you on that, but that's how I understand it. They are saying 425 is it.
So nobody is seeking to uphold the judge's order at the first appeal. I'll wait.
Yes,
but I think we need to be clear about that.
Yes.
Yes, anything else?
Just finally then, I think I've already addressed you on the fact that what the debts comprised in relation to the 257,000. But then finally, really just the discrimination point. We say that if the genders were reversed, there wouldn't be a judge who would make an order that's being suggested or that was made by Mrs Justice Judd. If there was a wife who was a primary carer for the first 5 years of or significant caring role, if there was a husband who was saying over 11 years she contributed nothing, career layabout, etc. And His Honour Judge Robinson set out what he says his contributions were at page 104, paragraphs, I think it's 8 and 9, and then again later on in 13 and 14. It would be a bold husband indeed who ran a case like that, but that's what happened, and we say it's already a low amount, and that's why the cross appeal should fail, unless I can assist your ladyship or.
No, thank you very much. That's very clear, Ms Owens. Yes, Ms Phipps, could you help us before you launch into your counter submissions, just on where you are about outcome?
Well, my client's primary case is that there should be no charge and there should be no payment of $200,000 to the husband's costs. But if you are against me in relation to the no payment at all towards the husband's costs, then her fallback position would be to uphold the decision of Mrs Justice Judd. Potentially, I would argue, with an additional trigger, which would be TM turning 18. But her primary case is that there should be no charge and no payment towards the costs.
Thank you, that's very clear.
I'm going to begin, if I may, with the issue of principle that's at stake in these cross appeals before I turn to the specific grounds of appeal. In my submission, the point of principle, which is before the court today, is the treatment of costs liabilities in cases where the assets are non-matrimonial, and therefore the claimant's claim is assessed by reference to the needs rather than the sharing, or indeed, but vanishingly rarely, the compensation principles. My overarching submission is that it is wrong as a matter of principle and fairness for the payer in such cases, A, to be regarded as the insurer of the other party's costs, and B, and this is the submission which I made to Mrs Justice Judd, to be left in a worse position than they would have been in had a costs order been made against them, which could only be justified as a consequence of their conduct, and even then would be subject to assessment either on the standard or indemnity basis. My lady, your lordships, you are of course very familiar with the general rule as to costs as set out in the family proceedings rules, and I've set that out in my skeleton argument, which is at page 52 of the bundle. Can I just apologise whilst I'm on my feet that my skeleton argument appears to have come out in tiny print? I'm not entirely sure why that is.
Well, I thought it was the age-old trick of trying to exceed your 25 pages by dint of using the smallest font you could possibly...
It was not deliberate on my part. I suspect it's because it's a PDF, but I do apologise, and I hope it didn't...
And I was in practice, you used to call it the Bruce Blair font.
It was in 12 originally. So page 52, I set out the rule as it is now in Rule 28.2.3, which is, of course, 5 initially, which is that the general rule in financial remedy proceedings is that the court will not make an order requiring one party to pay the cost of the other party. Of course, the court retains a discretion to make a costs order, which is set out in Rule 28.2.3, subsection 6. The court may make an order requiring one party to pay the costs of another party at any stage of the proceedings where it considers it appropriate to do so because of the conduct of a party in relation to the proceedings, whether before or during them. And then in subsection 7, specific pointers are set out in the rules for the court to consider. And of course, the rules have now been amplified or clarified further by the addition to Practice Direction 28A 4.4, which I haven't put in my skeleton argument. But this is guidance to the court in relation to the conduct issue. And the rule reads as follows. The court will take a broad view of conduct for the purposes of this rule and will generally conclude that to refuse openly to negotiate reasonably and responsibly will amount to conduct in respect of which the court will consider making an order for costs. This includes in a needs case where the applicant litigates unreasonably, resulting in the costs incurred by each party becoming disproportionate to the award made by the court. Where an order for cost is made at an interim stage, the court will not usually allow any resulting liability to be reckoned as a debt in the computation of the assets. The reason I bring that to the court's attention is to make this point, that a costs order can be made against a needs claimant if they have litigated unreasonably, resulting in the costs incurred by each party becoming disproportionate to the award made. And it is clear from this rule that needs-based awards are not sacrosanct. The general rule, therefore, is that there should be no order as to costs and that it is only conduct which would justify an order for costs against a party. And in my submission, the clear purpose of the no order as to costs principle was to incentivise parties not to run up costs because, except in cases of misconduct, there would be no one else to pay those costs. And in my submission, it is contrary to the general principle established in the rules for a convention or practice to develop that in needs cases, the paying party should be liable for the costs of the claimant. For, as I've said, this would put the payer in those cases in a worse position than they would have been in had an application and indeed an order for costs been made against them. In order to make an application for costs, the claimant has to persuade the court that the other party has behaved in such a way that their conduct justifies such an order being made. Of course, and I've made this point in my skeleton argument, and I don't propose to labour it, if a costs order is made, it will be assessed, either on a standard or indemnity basis. Commonly held benchmark is that on a standard basis, it would usually reduce to about 70% of the overall bill. Obviously, it's higher on an indemnity basis. And I have referred the court to Mrs Justice Roberts' decision in A, B and C, D, where she considers the question of indemnity costs and makes the point that in order to secure a costs order on an indemnity basis in financial remedy proceedings, the claimant has to show conduct to obtain an order in the first place, but that conduct has to be unreasonable to a high degree, not merely wrong or misguided in hindsight. The reason I've referred the court to GW and RW is to make the point that the no order principle operates fairly, subject to issues about costs disparity, in cases where the assets are matrimonial and the court is determining how to divide the fruits of the marital partnership. In these circumstances, each party is spending the matrimonial assets on costs, thereby reducing the assets available for distribution between them, so they both feel the impact of the costs liabilities. And I have set out for the court in my skeleton argument at paragraph 18 what Mr Justice Mostyn said in GW and RW, and if I can just take you to that, it's at paragraph 18 of my skeleton argument.
Yes, thank you.
Mr Justice Mostyn was, of course, instrumental in the abolition of the Calderbank letters and the change in the rules, and he set out in GW and RW, which was later discussed in Norris and Haskins, the reasons why he considered the Calderbank principle to be unhelpful in ancillary proceedings. And so he specifically said in paragraph 18, it's very easy to see why in an era where the wife's claim was perceived to be against the husband's money for a sum necessary to meet her reasonable requirements, costs should prima facie follow the event. Her position was comparable to an ordinary civil litigant. It is much more difficult to apply the analogy in the post-White era, where the court's function is to determine the parties' unascertained shares in the pool of assets that is the fruit of the marital partnership. That is the submission I have just made, that the no orders to cost principle, of course, impacts on both parties in the same way in a case where the issue is the division of the marital pool of assets. He says, this is on page 55 at paragraph 20 of my skeleton, he said at paragraph 96 of this judgment, I should emphasise that the opinion I am offering is confined to the big money case where there is an identifiable pool of assets, the creation of which is referable to the contributions, both financial and domestic, of each of the parties. It would not apply where the wife's claim is specifically needs-based, for instance, where all or the majority of the assets are inherited or where the marriage is short. In such a case, I can see that the claiming wife can be more closely compared to an ordinary civil litigant, and that therefore the orthodox theory should perhaps more directly apply. So in my submission, in a needs-based case, the issue is this: if the costs liabilities are automatically included as a need, which is Mrs. Owen's argument, and paid by the paying party, then the claimant is insulated against the impact of the costs liabilities and has no incentive to settle or put forward a realistic position. The logical conclusion of Moylan and Friends' arguments is that in any case where a claimant is a needs-based claimant, the payer has to be responsible for costs, because otherwise they will not be able to meet their needs. And
your answer to that is your answer then that there really should be no such thing as a needs-based claim, because no one's needs will ever be met, because if they're driven to litigate, their needs are going to be eroded by the payment of their costs. No, therefore we should be saying that is the wrong approach, and that it should always be dealt with qua civil liability by an application for costs, and if you don't get them, tough. Your needs aren't going to be met.
No, I'm not. Approach? I'm not saying that. I'm not putting it as highly as that.
Really? Are you sure?
What I'm going to come on to this, but what I'm saying is this: that when the court is coming to exercise its discretion in relation to the costs element of any needs-based award, and I accept entirely that the judge has a discretion, then a rigorous approach should be adopted in relation to the consideration of the costs liabilities. Obviously, I'm going to come on to deal with the specifics of this case, but to simply say in a needs case, well, the costs are what they are, that the claimant can't afford to pay them and therefore the payer must pay them, it flies in the face of the no order principle in my submission.
Well, is it the payer? It depends how you define them as well, because if it's a hard debt, a liability that has to be cleared before needs can be met.
Well, there's two points. What I say is that the judge who is considering how to exercise his or her discretion has to consider that this is tantamount. A claim for costs is tantamount to making a costs order against the payer.
Why? Why can't it just be a hard debt?
Well, Mr. Justice Holman in Dagger, which is why I referred to this, and I accept it's entirely different on its facts, but if we consider what Mr. Justice Holman said in Dagger, the husband applied for a lump sum from the wife to meet his costs. Can I invite you to turn to this? It's 176 of the.
But he was earning over 100,000 a year.
But the point of principle applies. So it's 176 of the authorities. paragraph 67, Mr Justice Holman concluded that the husband simply did not have any objective, reasonable or justifiable need for any lump sum from the wife. His only pressing need, he said, is to clear his debts, but they are entirely referable to the costs which he has incurred in these proceedings. If I were to order her to pay him a lump sum with which to pay off those debts, that would be tantamount to making an order for costs in his favour, which could not be justifiable. So my submission is that when the court comes to consider the question of costs liabilities, they are in a different category from other liabilities, because any order for a lump sum is tantamount to an order for costs, as set out by Mr Justice Holman in Dagger.
So just so I'm absolutely clear
Yes.
about the principle you're saying,
Yes.
is your submission is that costs are in a wholly different category to different from any other debt,
Yes.
and this court or any court should regard them as directly comparable to a costs order.
As tantamount to a cost order, yes.
So we follow that on back to what I was asking you. Therefore, they should only ever be met, regardless of the impact on needs, if you would make an order for costs as a result of litigation misconduct.
I don't consider that I can put the case as highly as that.
I'm sorry, but I need to know your cases, because that must be the logical conclusion, mustn't it?
I'm going to come on to look at the authorities in a moment, but what I say is that where costs are claimed as a liability in the context of a case where the assets are non-matrimonial, it is incumbent on the court to bear firmly in mind that the order it is being asked to make is tantamount to a cost order. And the court should consider, A, whether the costs have been reasonably incurred, B, whether the costs are proportionate to the case, C, whether it is fair that the paying party should pay those costs, having regard to their conduct, D, the conduct of the claimant and whether he's adopted a realistic position, and E, the principle that people cannot litigate on the basis that they are bound to be reimbursed for their costs.
Sorry, where's that in your, what paragraph is it?
That's not in my skeleton argument.
Oh, well, in that case, can I just went through those
Yes, of
rather
course.
quickly? So one, that the total is reasonable.
Whether the costs have been reasonably incurred.
Right, but just a minute. Next.
Whether the costs are proportionate.
Yes.
Whether it is fair that the paying party should pay those costs, having regard to their conduct.
Wait a minute.
The conduct of the
Just
claimant and whether he's...
Just a minute.
Sorry.
It's just if it's not down, I need to make a
Of
note
course,
it,
of course.
Please. Therefore, the paying party should be responsible, given the paying party's conduct.
The conduct of the claimant and whether he's adopted a realistic position. And the principle that people cannot litigate on the basis that they're bound to be reimbursed for their costs. In essence, my submission is that the court needs to apply a rigorous analysis to the claim that is made for costs in a needs-based case.
Just so I understand, that list is your distillation from thinking about the appropriate principles rather than being taken from any particular judgment?
Yes, and I'm going to
Yes.
I'm going to take you to the authorities now, but that was my distillation of the authorities I'm going to take.
So I rather thought you were just adopting what the cost rules say. Because as I understand your submission, you're saying that a party should not be able to circumvent the rules as to costs by simply asserting, I have a need, which includes my costs. So the court should, in essence, look at, apply, consider the criteria set out in the cost rules, which I thought reasonably incurred, whether proportionate.
Well, in essence, I have,
Conduct.
yes, I accept that.
Rather than just throwing that all out of the window and ignoring it and saying, well, it's a need, it has to be paid.
Exactly.
But doesn't that take us back to what I put to you a little earlier? What you are saying is unless you would have got a cost order, you should not have this debt as part of your needs-based settlement.
I'm not
award, I should say.
I'm not putting it as highly as unless you would have got a cost order, you're not going to get any payment towards your costs. What I'm saying is that it needs to be, the assessment of the fairness of it needs to be more rigorous than, for example, His Honour Judge Robinson carried out in...
Right. Well, one of the things you've not put into your features that you should say, should define the proper approach, is the judge allowed to take into account the impact on the needs-based settlement?
Of course the judge is allowed to, but needs are not sacrosanct. That's my point. And the danger of the argument that Moylan and Friend is running is, as I think I've already identified, that if a needs-based claimant knows that their needs are sacrosanct, they will be able to incur whatever costs they want, knowing that the other party will pay the bill.
Well, and presumably one's allowed to take into account the wide definition of need. So if you're a multi-billionaire and it means 8 bathrooms instead of 10, or no weekend nanny, only a weekday nanny, that's going to be very different between it's either a house and universal credit or no house and universal credit.
Of course, I would have to accept that there's a difference between a big money case and a smaller money case. But as I'm going to come on to consider in a moment, the case of NB and EB, of course, the husband was left, in my submission, in what might be described as a predicament of real need.
Is that the case, the rented house?
That is.
But they'd always lived in a rented house. That was the whole point.
No. That's a different. This is the case. This is the case where he was an artist. And living effectively in his artist studio. Perhaps it would be helpful if I take you to that.
Just before you
yes.
do, going back to my Lord's point, you've quoted in paragraph 12 of your skeleton from the family procedure rules, the list of matters to be taken into account.
Yes.
Under the rules. So how far should a judge go beyond that list in determining the impact?
Well, what I'm saying is that I accept that it is a discretionary exercise, the determination of whether a lump sum should be paid towards costs. And of course, the court must have, in relation to costs, there are safeguards which are set out in the rules. I'm not suggesting that there is that it should be harder to claim a lump sum payable referable to costs than it would be a costs order. I hope I haven't given that impression of my submissions. If that answers.
But you're saying, but the thing about the costs order is that we all know is because of the no order principle, effectively, if I can put it in shorthand, you don't get a cost order unless there's been litigation misconduct.
Yes.
Now, but surely that must be different from a needs case, because you're saying that in a pure needs case, given that costs will inevitably erode the satisfaction of the need award, you don't get anything in your award to cover that debt unless there's been litigation misconduct. That must be what you are saying.
I'm not putting it that highly. All I'm saying is that in the exercise of his discretion, the judge has to consider, firstly, that it's tantamount to a cost order, and secondly, to consider the points I referred to as to whether or not it is fair for that lump sum to be paid. And of course, within that analysis, of course, the judge is going to be influenced by the needs. But to simply put it, as Moylan and Friend has done, that in a needs case, the costs must come from the payer because there's nowhere else for those costs to come from, in my submission, flies in the face of the general principle that there should be no orders to costs in financial remedy proceedings. And the effect of it would be that the claimant looks to the payer to indemnify their costs. And we know from the authorities I've referred to in my skeleton argument that High Court judges have taken the view that the needs analysis cannot be sacrosanct and that consideration has to be given to how the costs have incurred, the reasonableness of those costs being incurred, and whether or not they're proportionate. And in both the cases, MB and EB and WG and HG, of course, the needs-based award were invaded, if I can put it that way, by the necessity for the claimant to pay some of their own costs. So if I can perhaps take you to those authorities, I have referred to S and B in my skeleton. I don't really propose to spend much time on this. I was just wanting to make the point that that in S and B, the husband was in effect ordered to pay £112,000 towards the wife's costs. So when the judge at first instance decided that there should be no order as to costs within that case, in fact, the effect of the order was not no orders to costs, but that the husband was paying the wife's costs, which is why he imposed the charge. So perhaps if I can just very briefly, if I may, take you to that. It's at 55 of the authorities bundle. His analysis is at page, Mr. Justice Wilson, as he then was, his analysis is at paragraph 24, where he determined that of the lump sum that the husband was ordered to pay to the wife of £475,000.
Sorry, did you say 24?
Paragraph 24, page 62 of S&B.
Thank you.
This is where he was setting out the breakdown of the capital fund awarded to the wife. So it was going to include her housing fund and should also allow for the wife's outstanding costs, which would have to be paid from somewhere. She could, over the page, she could secure, so he must have concluded service or mortgage with which to pay the outstanding costs of £32,000. Subject to the possible need at the end of the proceedings to make some order for costs which would alter the effect of doing so, the outstanding costs of £89,000 referable to the financial proceedings should be added into the lump sum, and the lump sum should be 475, being as to 89,000 the outstanding costs, and as to the balance 386 for estimated overall housing fund. In paragraph 26, the judge said, I hold that provided when he came to determine any issue as to costs, he bore well in mind what he had done, the judge was fully justified in adding into the lump sum payable by the husband the wife's outstanding costs referable to the financial proceedings. Indeed, it was the only realistic solution open to him. Then, when he comes to deal with the costs order, or the making of no order for costs on page 66 of the bundle, he says, and the court, my lord, you might have some sympathy with this sentence given the issues at play in this appeal. Despite the large sums often in play, judges seldom determine issues of costs with a degree of thought which they give to the substantive issues in the case. I must certainly plead guilty to that charge. He said the judge needed to approach the issue of costs with two facts firmly in mind. Within the lump sum, the husband was already paying £89,000, and the husband had already contributed £23,000 by way of maintenance pending suit provision. And that is why he said, under orders already made, the husband had paid or would be obliged to pay a total of £112,000 towards the wife's costs of the financial proceedings. Thus, without having been given the opportunity to challenge the amount of the wife's costs in the course either of a detailed assessment or even of the conventional representations prior to summary assessment, the husband had already been obliged to pay 70% of the wife's estimated costs, a sum probably higher than would be identified on any detailed assessment on a standard basis. That, of course, is one of the arguments I make in this appeal. And so his ultimate solution is on page 68. Paragraph 45, with great respect to the judge, that comment confirms my view that he fell into appealable error even in this most discretionary of areas. I believe that when he made no orders to costs, the judge was proceeding on the usual, but in this case invalid assumption that the effect would be that the wife would bear her own costs. And he forgot that by virtue of other orders, the husband was already paying at least all the wife's costs on the standard basis. In truth, the effect of his making no orders to costs was not to punish the wife for her error in pursuing the issue, it was to punish the husband. And that is why he imposed the charge. And I also draw, my lords, your attention to paragraph 47, about 4 lines up from the end. So I am thrown back upon a charge for which I share the judge's lack of enthusiasm. Nevertheless, to save a litigant, since she cannot pay him now, she should never pay him, is to stand justice on her head. So in that case, in order to truly end up with a no orders to costs arrangement, the learned judge imposed a charge. I just wanted to deal, if I may, with a point that the learned friend made, which I was a little confused by. I'm not sure it particularly goes to March, but it's on page 65 of the authority summary. This is the point she made in relation to S and B. She emphasised to the court at the bottom of paragraph 35, save in the event that other factors as yet unconsidered, for example in relation to costs, compel a different result, I uphold the conclusion that the wife is likely in the years ahead to earn the value, free of a husband's charge, of a modest 3-bedroom flat in West London. The way I read this judgment, the judge was referring back to paragraph 34A, where he says that as the likely primary carer throughout his childhood of a child still aged only 3, the wife was likely to make a substantial and protracted contribution to the welfare of the family, and that although she would need to work full-time, her responsibilities to the child would shackle her ability to apply herself unconditionally to the development of a really successful career, and it might be too late for her ever to do so. My reading of the end of paragraph 5 is referring back to the point that the wife was going to make continual contributions to the welfare of the family. So perhaps the word earn is a little inapt, but my understanding of the judge's decision is that it refers back to her contributions as a mother. Moving on to the more recent cases. WG and HG at 134 of the authorities bundle, decision of Mr. Justice Francis. The resources in this case were all non-matrimonial. Page 140 at paragraph 11. Mr. Justice Francis says all of the resources in the case were brought into the marriage by the husband. This is a contribution unmatched by the wife. The wife does not need to be defensive about this. And over the page on 141, he says in paragraph 12, in K&L, Wilson LJ, as he was, held that the recognition of the wife's considerable unmatched financial contribution in that case was not discriminatory. It was, on the contrary, a recognition of the substantive differences in contribution. I pause simply to avoid having to come back to this paragraph in relation to the ground of appeal that the decision of Mrs Justice Judd was discriminatory because it is said the husband is receiving a low proportion of the assets. I simply refer back to what is said in K&L and WG and HG. It's not discriminatory in cases where the assets are non-matrimonial to make that distinction. In this case, the wife's claims were determined by reference to her needs for housing and for a Duxbury fund, as my learned friend identified in her submissions. The wife had spent $220,000 on the Children Act, Family Law Act and divorce proceedings. That's at paragraph 6 of the judgment. $100,000 on financial remedy proceedings. And there was also $71,000 in interest on her litigation loan, plus the arrangement fee of £9,000. And that's, I collect those figures from paragraph 14 of the judgment. By the time of the final hearing, the wife owed £926,000 in respect of her outstanding costs and litigation loan. That's at paragraph 79. And she sought £915,000 from the husband in respect of those costs. And I just wanted to draw my Lady Lordship's attention to paragraph 15, which is on page 141 at letter H. Wife's counsel submissions in relation to costs. The fact that this is now being run as a needs case by the wife led her counsel, Jonathan Southgate QC, to make what I regard as a rather remarkable proposition, namely that the wife is entitled to a full indemnity in respect of all of her costs. The rationale behind this is that her costs are a debt that needs to be paid, and that in a needs case, her needs must be met. Mr. Southgate agreed with me that the usual outcome in a sharing case would be each party paying his and her own respective costs. He sought to argue here that his client could be better off than she would have been in a sharing case because this cost is a need. The reason I draw the court's attention to that is because Mr. Justice Francis regarded it as a rather remarkable proposition that the wife was entitled to a full indemnity in respect of all of her costs. And he dealt with his decision in relation to this at paragraph 90 and 91 of the judgment, which start on page 158. Mr. Justice Francis said that he was faced with the vexed question of what to do about the wife's litigation loan. Whilst I recognise that she has a significant debt in respect to the Family Law Act proceedings and the Children Act proceedings, it seems to me that I have to tread very carefully indeed here. Children Act proceedings were compromised by an agreement the children split their time more or less equally between the parents. The wife incurred very substantial costs and the husband did not. Paragraph 91. Against that, people cannot litigate on the basis that they are bound to be reimbursed for their costs. And I don't accept that that is simply a soundbite, but a statement of principle. The wife has chosen to instruct one of the highest regarded and consequently one of the most expensive firms of solicitors in the country. No one enters litigation simply expecting a blank cheque. A judge in a position as I am now in is facing the invidious position of seeing his or her order undermined by the extent of litigation loan or costs liability. He grapples with the difficulty and then said, doing the best I can to recognise that her costs are excessive, to recognise that she's presented an unreasonable case in financial remedy proceedings, but to recognise that her Duxbury fund cannot be completely undermined and that the husband's offer was too low. I'm going to add to the lump sum an additional $400,000, which is a little bit less than half of the total sum due. So the wife, in that case, had to pay a little over $500,000 of her own costs, which was going to deplete her Duxbury fund. And in paragraph 93, Mr. Justice Francis said, I recognise that this will deplete her Duxbury fund. I have very carefully considered whether this is fair. It might be said that I have assessed her needs at a given figure. If I have done that, then how can I leave her with a lower sum, which by definition does not meet her needs? This conundrum happens in so many cases. People who engage in litigation need to know that it has a cost. My lady, you've already made the point to me that the financial background in that case was significantly different to the financial background in this case, which of course is right. But can I direct your attention to the case of MB and EB number 2, which is at 179 of the authorities bundle. The wife, in fact, in this case, was very wealthy. She had assets of not less than £50 million. The husband, though, was not in remotely the same position. Pursuant to an earlier agreement, the husband had received an apartment which was rented out and from which he received an income, and he was living in what was found to be unsuitable accommodation, effectively living in his artist's studio. And he had no realistic prospect of meaningful employment. He was a struggling artist and he had health issues. The wife had already paid £236,000 of the husband's costs pursuant to a previous order, secured by way of charge against his property. At page 183, my learned friend has already taken you to this page. Paragraph, so I won't repeat what it says in paragraph 15, but paragraph 16, the outcome of it all is the husband has spent, or will have spent, by the end of the case, the staggering sum of about £650,000 in costs. The wife has funded £236,000 of that sum. The husband has paid £36,000, and the sum outstanding, inclusive of interest and solicitors, is around £380,000. This is wholly disproportionate to what has been in issue. The judge decided, Mrs Justice Cohen decided to award the husband a Duxbury fund of £325,000, which would enable the husband to receive £25,000 for, that's on page 185. Forgive me, he received the Duxbury fund plus £10,000 for a car, which was £335,000. That's dealt with in paragraph 27. Paragraph 28 brought the judge to the issue of costs. Again, in this case, Mr. Mitchell, appearing on behalf of the husband, described his submissions on this aspect as bold, and that was certainly a fair description. He says that I should make an award that would cover the whole of the husband's costs because he says that the costs have arisen as a result of the wife seeking to run a case that the marriage effectively came to an end in 2002 or 2004, and the relationship between the parties ended there and then, when in fact I have accepted and found there were elements of codependency right up to 2016. He goes on to say, in a needs-based case, it is inevitably the payer who ends up having to pay the costs because otherwise the needs cannot be met. That's the same submission that was described as remarkable by Mr. Justice Francis in WG and HG, and it is the same submission that is being made to this
just
court today.
Going back to what Mr. Justice Francis said, I do think we have to I take your point completely, but it does say, that doesn't say, says it's made in reference to that case. He's not saying a general principle necessarily. We looked at paragraph, was it paragraph 15?
Paragraph 15, my lady, yes. Yes, I accept that. I accept
Needs case.
I accept that he was making the comment in relation to that particular submission in that particular case, but then go on to say the rationale behind this is that her costs are a debt that needs to be paid.
But then we have the whole of the factual matrix.
I accept that, which is why MB...
But I think what you're trying to do is saying there's the principle established, being carried on through by Mr. Justice Cohen, and I'm not sure it's that simple.
I understand, but the point is that both of these financial remedy judges took the view that, as I've submitted, the payer cannot be the insurer of the
I don't think
needs-based.
anyone's suggesting that the payer should be an insurer, are they?
Perhaps insurer is the wrong word, but effectively...
Or that unreasonable amounts of costs should be borne by the paying, or the person that owns the non-matrimonial asset.
Yes.
I mean, isn't that a given?
Well,
You're saying they shouldn't have anything unless there's a costs order, unless there's the equivalent of a cost order by reference to those issues that would allow you to have a cost order made.
well, I hope I'm being a little bit more nuanced than that, but
You're saying there's a discretion, however.
Yeah,
I do it by reference to the rules.
I take your point. I am trying to be a little bit more nuanced than that, but I take your point. My submission is that intellectual rigour needs to be applied when considering this point.
Well, I certainly accept that.
In relation to MB and EB, and this is the point about the different factual matrix in WG. What happened in this case was that all the husband had was his apartment. I don't collect from the judgment what that was worth, but he had that, and then he received the
335.
The three, yes. So then the judge went on to order that, coming on to consider the question of costs. I'm sorry, I got slightly derailed. So when he was considering the question of costs, he did, in fact, consider the in Rule 28.3, and he went through the provisions which I have already taken, my lords, to. He also reminded himself of the amendment to Practice Direction 28A, and then he, paragraph 30, what he thought the reasonable level of costs would have been had the litigation been conducted reasonably, which he assessed at 150,000.
Sorry, what were you?
So that is at paragraph 30.
30.
30, yes, at page 185. What Mr. Justice Cohen said, on any proper presentation of the case, this would have been a straightforward needs case, and even with the expense of top firms of solicitors, should not have cost each side more than 100,000. I accept there might have been an additional issue which would have needed to be resolved about quite what the relationship between the parties was between 2011 and 2016, but I cannot see how this would have increased the cost by more than about another 150,000 aside. Then goes on to consider the cost rule. And then his decision at paragraph 34, it is self-evident that the payment of something in the region of 1.25 million worth of costs between the parties is grossly disproportionate to what was in issue. I find the wife's offer was light, but I'm in no doubt that if there had been a sensible or any response, there would have been a quick resolution. The case has been conducted by the husband in a manner that I find to be irresponsible and unreasonable. Paragraph 35, I therefore cap her liability to his costs at 150,000.
Costs had been unreasonably incurred.
Yes. Then paragraph 36. The husband was left with his apartment and a lump sum of £485,000, but he was going to be left with his total costs. His total costs liability was £650,000, of which the wife was ordered to pay a lump sum of £150,000, and he had paid some of his costs himself. But he was going to be left in a very difficult financial position as a consequence of the costs that had been incurred. And the judge in that case did apply very consideration to the question of the costs and a lump sum payable, referable to costs, and rejected the submission that in a needs case, the costs have to be paid by the, I'm loosely using the word payer, which may be a little infelicitous, but the paying party because that's the only place the costs can come from.
He did get his reasonable costs.
He did get his reasonable costs, yeah. But what the judge did in that case was, as I've put it, apply intellectual rigour to the question. And he didn't allow the argument that the husband was going to be left not able to meet his needs to detract him from a consideration of whether it was fair for the wife to pay what the husband sought, $650,000.
Where we're left, though, says that in both WG and in MB, the emphasis from the court was you're not going to get unreasonable costs.
Yes.
And here we have, in this case, no such finding that there have been unreasonable costs.
Well, can I'll come on, if I may, now to deal with the specific.
But that's the position,
ground.
isn't it? I just want to be clear. In those cases,
Well,
there was unreasonable costs, but they were given some costs.
yes.
That amount of costs which were deemed to be reasonable.
Yes, but in this case, I'm going to come on, obviously, to deal with His Honour Judge Robinson's judgment. He found that both parties had behaved unreasonably. He found that both parties had put in unrealistic property particulars. And he found that the husband's case had been overcooked. So for my learned friend to put all the emphasis on my client is, in my submission, not an accurate reading of the judgment. And I'm going to take you to those elements of his judgment in a moment.
Was there anything else you want to deal with on the submissions? I mean, on the authorities?
I just wanted to make this point.
Of course.
That it would be a bizarre consequence of the application of the general rule that there should be no order to costs if the effect is to justify routinely making lump sum orders against the paying party, which are tantamount to cost orders, without the claim being subject to the same or equivalent rigour as they would be if an application for costs were made. In terms of the instant case...
Well, it's 3 minutes to 1.
I'm sorry.
Would that be a convenient
moment
if you're moving on from
Yes.
the issues of principles
Yes.
and authorities?
It would. Thank you.
Excellent. Thank you very much indeed. 2 o'clock.
Just going to turn the live stream off now, but it will record for 90 seconds, so what you say will be